with us is Professor Caprice Alves from the Metropolitan College of New York.
Hi, thank you. So, I'm here to speak, I guess, on behalf of consumers, from a consumer perspective, and to the point at which disciplinary charges or findings should be publicly revealed. I believe that complaints themselves, I agree with Professor Gillers, where he said that as soon as there was probable cause for a complaint to be processed, it should be publicized. I know that Judge Skello said that anecdotal testimony is not really valuable, but I'm going to give a few examples and then say that those things do speak to the process. They do speak to the structure of things and how the structure of things is flawed and hurts consumers. One example is, well, all three examples involve lawyers. So should I name the lawyers and give you the specific examples?
I prefer you not name lawyers.
Okay. Okay. One particular lawyer was brought to the attention of the First Department Grievance Committee for bad deeds, just unethical behavior with real estate and things like that. He was actually my lawyer, and I made a complaint against him for things that he was doing, and he actually tried to take my apartment somehow that I owned, and he said he was going to make me an investor and different things. I brought the bad behavior of this person to the disciplinary committee, and they didn't act on the complaint that I submitted. After 3 years of me trying to get the complaint processed against this person, they got tired of me and dismissed the complaint altogether. 3 weeks after the complaint was dismissed, he got arrested by the FBI. When I did a doctorate, and I just defended it last year, actually. And the title of my dissertation is An Analysis of the Perceptions of the Legal Profession Through the Eyes of Dissatisfied Consumers of Legal Services in Manhattan, New York, an Interpretative Phenomenological Analysis. While I was doing my case studies, my comprehensive exams, and I decided to do it on this particular lawyer and the situation with the First Department. As I was looking up things and doing my research for that case study, I found out that he was breaking the law for the whole 3 years that the disciplinary committee had his complaint. In Florida, he had someone sitting in prison while he robbed the family. He told the person to plead guilty, then he went into Amsterdam and he took the house, the rings, the cars, and everything from the family. He was rearrested, shipped back to Florida to face charges where he was practicing in federal court where he didn't have a license, and now he's in prison for 7 years. The second example is a gentleman, an attorney, a Brooklyn attorney, who represented an elderly Harlem woman with a property that she owned and bought, I think, in 1956 or something like that. The property, she paid about $198,000 for it, and it was worth $4 million now. She asked him to manage the building for her, and he did. He represented her. And first, he would keep the money from the tenants and not return it to her. And then he got tired of that slow process, so he just mortgaged the building and stole the whole thing. When a news reporter got wind of the story and the things that he was doing previously, they did a report on this particular lawyer and all of the outrageous bad deeds that he was committing. So he sued the reporter for defamation to stop the reporter from publicizing this information. Long story short, that person is now in prison. for 6 years in federal prison. And for the past year, although he's been in prison for a year now, the lawyer site AVO and the court system's website said that he was a lawyer in good standing with no disciplinary records to be found. The third example is a lawyer who represented me. I have a high-end co-op in Manhattan, and all we do is disagree. So we decided to go to court one year, and I hired a lawyer, and I guess he felt like he was in a win-win situation. I have this apartment, we have the building, he can't lose. So he was excessively billing and doing bad things, and then because I was challenging his behavior, he just decided to quit. But he kept all of the money that I gave him. After submitting these people to the disciplinary committee, all of the complaints that I submitted were dismissed. They would call each other and say not to represent me, the next lawyer, and things like that. All of the complaints were dismissed. So the only thing that I had at my disposal was the opportunity to submit a consumer review, which I did. I put a rip-off report on him online and stated exactly what he did. For the last 3 years and 2 months, he's been suing me for defamation frivolously because he says that my consumer review is not true, and I'm saying that is true. We are now on the 4th judge because they keep quitting. The judges don't want to be bothered, and they've been doing improper things, causing one judge to quit on the record and say that they were sending him things improperly and all of these things. But either way, we're on the 4th judge, 3 years and 2 months later, no end in sight. I'm fighting back against him and his frivolous claims, which I don't think he expected. But this is what's happening. So, anecdotes aside, the first department receives 3,300 complaints a year. Out of the 3,300 complaints that they receive, they dismiss over 98% of them. The confidentiality laws don't allow consumers to know that certain lawyers are capable of certain behaviors. If you don't know that these lawyers, particular lawyers, would be capable of particular behaviors, there's no way in the world you could be an informed consumer. You're susceptible to the experiences of the 3 lawyers that I outlined. That particular lawyer that's suing me has actually been in litigation and is still in litigation with some of them, 26 clients that he's either suing or are suing him for excessive legal fees. So that's what I'm speaking to today, the fact that the complaints should be public as soon as there is probable cause, or else consumers are not protected from the egregious offenses of bad apples.
Ask the staff in the disciplinary committee for either an oral explanation or a written one, and did they give you either?
Yes, sir, I did ask many times.
Tell me what the response was, please.
The response is always that they cannot talk to you and tell you certain things because of confidentiality laws. The written complaints were never any more than we did an investigation and we didn't find wrongdoing. And that's about it. In fact, I was told at one point that consumers are not entitled consumers don't have the right to the disciplinary committee, that the disciplinary committee is sort of a luxury or just I can't think of a word to use, just sort of a luxury that's in place, but it's not that consumers are entitled to it. Therefore, they don't give out their email addresses and give you complete access to the disciplinary committee people.
Thank you.